our streets, our communities. Work with our justice system to speed up sentencing on anti-Semitic attacks, so there is a stronger deterrence factor, as we do with riots. And we need stronger powers to tackle the malign threat posed by states like Iran, because we know for a fact that they want to harm British Jews, which is why we will fast-track the necessary legislation. And yet, the truth is, while we can and we will bring the full power of the state to bear on this, this is about society every bit as much as it is about security. At moments like this, we often say, this is not Britain, that these attacks are an affront to British values, to British tolerance, British decency. But they keep happening, don't they? And so today, instead, I will simply say that our values are not a gift handed down generation to generation. They are something we earn each day through action. They come from us. Anti-Semitism is an old, old hatred. History shows that the roots are deep. And if you turn away, it grows back. Yet far too many people in this country diminish it. They either don't see it or they don't want to see it. Take the marches that happen regularly across Britain. Of course, we protect freedom of speech and peaceful protest in this country. But if you are marching with people wearing pictures of paragliders without calling it out, you are venerating the murder of Jews. If you stand alongside people who say globalize the Intifada, you are calling for terrorism against Jews. And people who use that phrase should be prosecuted. It is racism, extreme racism. And it has left a minority community in this country scared, intimidated, wondering if they belong. So I say again, this government will do everything in our power to stamp this hatred out. We will strengthen our security and protect our Jewish community. But I also call on everyone decent in this country to open their eyes to Jewish pain, Jewish suffering, and Jewish fear. I call on everyone to come together and fight anti-Semitism. And I call on everyone to fight for the decent, respectful, tolerant Britain that I and millions of people love, so that our freedom and our values can still speak loud and true to a community that can no longer take it on faith. Thank you. I will now take a couple of questions, I think first from Paul.
Prime Minister, you've just been heckled on a visit to Golders Green. One of the victims of this attack says he feels let down and the government isn't doing its job to make Jewish people feel safe. Can you say hand on heart that you have done everything you can, and do you owe the Jewish community in the UK an apology?
Well, can I start by saying I absolutely understand the high levels of anxiety and concern that there are. They're reflected in the various reactions over the last day or two. I completely understand. That anxiety has been there for a very long time. And the appalling terrorist attack yesterday made it worse. In terms of what we've done, we have called an emergency COBRA yesterday to make sure that we're coordinating the response and putting the necessary security in place. I pulled together the various criminal justice agencies this morning to make sure that together we can show that justice will be swift, effective, and visible to give confidence to people. We had already put in enhanced funding for security, and we'll put more funding in now. We're looking at what further measures we can take on protests, particularly in relation to chants, to banners, and the repeated nature of protests. We're, of course, looking at what more needs to be done in health and education. And we will fast-track powers to deal with malign state actors. So there is a lot that is being done. Of course, we need to do everything we can, but we do also need to ensure that this is something the whole country is prepared to call out, to see, and to fight against. Thank you. I'll take PA.
Prime Minister, the police have said that the suspect in this case had previously been referred to Prevent. This looks like another failure for that programme. Can we trust that Prevent can keep us safe from extremism?
The investigation is obviously still ongoing, and so we haven't got all the facts yet. But Prevent was reviewed, and we made changes after the Southport attack. We need to be open to learning any further lessons that may come out of this investigation, but we're at a very early stage at this point. Thank you very much.
close.
I love that.
There's like a big flash of light.
كمان هذا سام عيني
سبحان الله لا البسيب بيجيبوش الا اشكالهم هذا شيخويا يا زلمه بس بالمره ايوه لا شو اسمه بس بالمره نازل
شوف العالم بسوريا على البحر كمان بيسبح ما بتشرج البطارية منه هذا بتشرج رايح
بس على هذا الالتيتيود يعني هنضرب. حيضرب هذا. وينه جميل بسيم؟ جميل الجو حصل طلع؟
هلا انا لا مع الاي 74 بس معي 76 اه الايفون 17 شوف ولا الستابلايزر فيه تصور رو فيه وتقدر تلون بعدين شو اسمه الاكستندر تبعه تايمز 8 هو انا جبته هذا الافضل فيه ليش الموضوع انت برضه الفيديو بطل كمان واضح لا افضل تلاوي لا غير شيء غير لعبه ليش استكبار العالم استكبار العالم لا استخدم سوني معنا كتربيلر جرافات بس هيك هلا اللي ضارب بقوه تليفون هلا اللي نازل لا نازل فيه اوبو عاملين له لانس هازل بلاي بيحول هلا طول بالك هلا نازل شيء مهيئ فيه هن كل المستشاريين هذيك اليوم صورت
العاب شو عم بيصير؟ واحد
هو بيشتغل
واحد ثاني بيفكر في الوقت الثاني.
هذا شو 17 العادي 16 عفوا 16 يعني كيف يعني ما في شيء اسمه كاميرا بس كاميرا لا سبحان الله التليفونات صراحة وقت
لا
ضمن الزمن يعني بعرف لا صح لا انا بعرف غير السؤال الابد بعرف انا هون بلاقي كل قرايب كله بيكونوا كله مقورة مقورة عنده الآن عنده البرد انا ضبط الكل لا السفينة لا واصل هذا هالطوارئ هذه هالطوارئ شوف هو بعت لي الرسالة حسن هو بعت لي الرسالة عرفت ايه؟ والله لا
عليه البزورية دارك
هذه هي اللي كانت تعرفها؟ تموز ايه إضافة إلى ذلك هناك عشرات الغرش كما ذكرت على عدد من الطرق. نستطيع أن نعيد بالذاكرة ما كان يحدث خلال الحرب في هذه الأيام وما يجري اليوم في جنوبي لبنان على وقع الغارات والعتاد الإسرائيلية. عرف الزميل علي حرامي جولة على المنطقة الحدودية التي تعرضت لوابل من الاعتداءات الإسرائيلية، ونستطيع أن نرى مكانا يجرف الجيش العدو ويتحرك وقيادته وآلياته. وبالتالي 4 minutos. Léelo ahí, está bien.
Sí, sí, porque está muy... Sí, ya. Ya, porque yo creo que la avioncito llega un poquito más cerca de ellos. Supuestamente esta agua es a la mitad.
Apagaron el transporte.
Muy separado.
Bueno, es un Embraer, no es gigante, no es un Boeing, no es un Airbus, pero ya pagaron. Ya pagaron el transporte. Ya pagaron.
Vamos a revisar después.
Bueno, aquí sí, no sé por allá, pero aquí sí. Sí, sí. Ya, según a 4 minutos. Ahí viene, ahí está. Ahí está una abertura, mira. Ahí viene. Las luces encendidas sonando por donde está la ala roja. Ahí viene.
Se me fue una el avión con el agua y ya las otras. Siempre que Chema pasó una.
Prensa venezolana, vamos a repetir un momento el listón aquí enfrente de ustedes, ¿ok? Denos un momento, por favor.
A cortar la cinta.
allá para Venezuela, América Tierra, con calma, no corra. Vamos a entrar en filita india y nos vamos a poner atrás de la prensa de la Casa Blanca. Recuérdense de lo que hablamos. Atrás de la prensa de la Casa Blanca. José.
No, dame el trípode. Aquí, papá, que me meta cámara aquí.
Thank you all for being here today. We are so excited to have just arrived on the inaugural commercial flight from the United States to Caracas for the first time in more than 7 years. Thanks to President Trump's leadership, the United States and Venezuela are restoring our partnership, rebuilding economic ties, and facilitating unprecedented investments that will benefit both the American people and the Venezuelan people for generations to come. Today, you will hear remarks from Felix Plasencia, Venezuela's chargé to the United States, John Barrett, chargé of the United States Embassy in Caracas, Ryan McCormick, Department of Transportation Undersecretary, and Jared Agan, Assistant to the President and Director of the National Energy Dominance Council. Following remarks, we will take just a few questions. Felix, the podium's yours.
Thank you. Thank you. First of all, bienvenidos a Venezuela. We're so very happy. We're thrilled to have you all here in this very first flight direct from Miami to Caracas, and this should be the first one of many. I understand they're already queuing for some more flights. So welcome. I'm very happy to have you here. The Minister for Transport is welcoming you on behalf of President Delcy Rodriguez and the government of the Bolivarian Republic of Venezuela. You're very welcome to Caracas, to Maiquetía Airport, and I hope this visit will be a very profitable visit. We're working intensively on increasing and improving our bilateral relationship. This is a very step mile, an example of how committed and how much we're moving forward for the best. Thank you very much for being here today.
Well, good afternoon, everybody. Today marks another historic milestone for US-Venezuela relations. We are witnessing the rebuilding of our economic ties, the reopening of Venezuela to global commerce, and the reconnecting of our two countries. The resumption of commercial passenger flights between the United States and Venezuela is a direct result of President Donald Trump and Secretary Marco Rubio's three-phase plan. Under their leadership, today we are sending another clear signal to the global market that Venezuela is once again open for business. Thank you to Venezuela's interim government for their efforts to make today's inaugural flight possible, achieving this at record speed. I congratulate American Airlines for their immense work in becoming the first U.S. carrier to reestablish this vital link. I also want to acknowledge the robust media representation here today. Your presence is vital to sharing this historic step with the world and telling the story of a new Venezuela. By reconnecting Miami and Caracas, the United States and Venezuela are restoring a critical commercial artery that will accelerate investment, rebuild supply chains, and strengthen the bonds between our people and our nations. This is the first of many expanded connections between the United States and Venezuela, as Venezuela looks to reclaim its position as a regional economic and energy powerhouse. Under President Trump's leadership, the United States remains fully committed to Venezuela's economic recovery. Today, the results speak for themselves. Direct flights are back, commerce is flowing, Venezuela's economic engine is ramping up, and we're just getting started. Thank you very much.
Good afternoon. It's great to be with you all here today. As has been said many a time today, President Trump gave the directive to Secretary Duffy that we needed to restart flights to Venezuela quickly. Within the same day, we eliminated all the bureaucratic red tape in order to make that a reality. And today, we're bearing the fruits of that labor with the maiden voyage of this American 250 aircraft here to Venezuela. It's the maiden voyage, but there are many more flights to come, both with American Airlines and other interested U.S. carriers. We're excited about what the future may hold between Venezuela and the U.S. The future is very bright in aviation, and we look forward to working together closely on our shared issues. Thank you.
Hi, I want to thank everybody for being here. I particularly want to thank Delcy Rodriguez for welcoming us, for having us here today. This is such a great celebration. Today's a celebration. But what today also is actions. President Trump is a man of action, and what you're seeing today is action take place. This is the result of the hard work of a lot of people and the hard work of building this relationship. Venezuela has an excellent charge, excellent ambassador. He's in my office. I think he's been in my office twice a week since he's been in his position. The action of having American Airlines do this daily flight, this would normally take months to do, and they did it in a matter of weeks. That's important because that is Trump speed. That's what the Department of Transportation is talking about. We are moving at Trump speed to get things done. There's been a lot of coverage already about what is happening in the energy sector on oil and gas and mining, and today we're going to make more announcements of all the progress that is happening on that. But none of this happens in a vacuum. All of these things are connected. So the fact that you now have commercial flights daily that are happening here, that sends a message to the whole world that there is this strong commitment between the United States and Venezuela. So you're going to read about great energy deals, but how do you get the employees down here? How do you get executives down here? Having this kind of regular commercial relationship between the U.S. and Venezuela, that is an action, that is real results, that is going to translate into even more real results. What the president likes is action. He also likes deals, and he likes progress, and we're seeing all of that in a very short period of time. It's hard to believe how short of a period of time it is, and look at the progress that has already been made. And the fact that we're all here, standing here today, off the first flight, just demonstrates how quickly the Trump administration is moving, how quickly Delcy Rodriguez and her administration is moving. So there is going to be a long relationship in the future here, but just look at what has happened already in a matter of months, if not weeks, and you're going to see more of that to come. So I'm super excited. I was in the Oval Office with President Trump just a couple days ago. I mentioned to him we were coming. He was very excited about this trip. He's very excited about the actions and the progress, and he's very excited about more deals to come. So I'm excited. We're all excited. Thank you for having us here today, and looking forward to a great visit. Thanks all.
We'll now take a few questions from one of these four. We'll start with the Wall Street Journal. Vera?
Hi, Vera with the Wall Street Journal. I think Mr. Barry, you just mentioned that the first phase of stabilization was practically complete. Are we moving into the second phase, and are the second and the third happening around the same time, or how does that work?
Yeah, right, thank you. So it's a three-phase plan, and we feel very strong about the first phase, stabilization. I arrived a week ago, and I found a very calm and peaceful city that is bustling and ready to do business. And that's why I'm very focused. This embassy is very focused on the second phase, which is economic revitalization. And that's why this flight is so important today, because this is really opening the doors not only to passengers, but to students, cargo underneath the belly of the plane that's connecting these two countries in a way that we haven't seen for 7 years. So that's where we are absolutely laser beam focused on this phase 2, economic revitalization.
In 2019, it was President Trump that banned commercial travel to Venezuela. 7 years later, the same government here in Venezuela is still in power, and some of the factors that the president cited then are still present. Can you explain what made you guys make the decision to restart life and address some of the criticism that this is solving a problem of the Trump administration's own?
Look, the important thing is that because of decisive leadership from President Trump, we're here today, right? And we have this three-phase plan that the Secretary and the President have established for us, and it's very clear. And that part, at this stage, like I said, is focused on economic revitalization. And our partner to do that is with the interim government. We feel that's the best way forward to make sure that the decisions that we're making today, and this group is coming with a lot of business deals that you'll hear about in the next couple of days. This is going to put into the soil deep roots of economic growth that can take hold so that Venezuela is in a good position to move to transition at the third stage of this three-phase plan. So right now, again, this focus right now is ensuring that we have an investment climate here that offers the kind of assurances that quality U.S. firms and U.S. investors require to have a high level of confidence in the potential, because the potential is here. And so our work at the embassy, and we're represented here by our visitors, senior visitors from Washington, is to do everything we can to establish what is going to be a very strong, solid investment climate that provides all of those assurances that our U.S. investors require.
Absolutely. So the Department of Transportation works closely with the Department of Homeland Security in order to do an assessment of the airport, make sure that the airspace is safe, the airport's safe. And of course, you actually need an application from a carrier who's interested in coming. American Airlines, within an hour of President Trump saying he wanted to reopen commercial aviation to Venezuela, they had an application pending before the department. Again, I know that many other U.S. carriers are interested. We're expecting additional announcements from them in the near future.
Thank you, everyone.
Thank you.
Okay, we are calling two matters simultaneously. The matter of Dakota Mortensen and Taylor Frankie Paul, case number 264901444, and the matter of Taylor Frankie Paul and Dakota Mortensen, case number 264901819. Council appearances, please.
Brent Hall on behalf of Dakota Mortensen, who is present, both petitioner and respondent, but yes.
Okay.
Good afternoon, Your Honor. Eric Sweenard and Ryan Ficklin for Taylor Frankie Paul, who's present with us as well.
Okay, well, oh, yes.
Mike McDonald, Garden ad litem for the minor child.
We'll have one attorney each making oral argument. Is that right?
Yes, Your Honor.
All right, very good. All right, so at the last hearing, I had expressed some hope that there might be some resolution to these matters. Were there any efforts made in that regard?
I don't know if I'd call it efforts fully, Your Honor, but I mean, we've definitely contemplated where we're at, and we've had some good discussions about the current parent time schedules. So,
okay, any resolution on anything?
I don't believe so, Your Honor.
All right, well, the first matter was the one that was filed by Dakota, so we'll go ahead and hear from you, Mr. Hall, first.
Thank you. All right. Record's good? Good. Well, Your Honor, today we have two competing protective orders, one from Mr. Mortensen and one from Ms. Paul. I'll start by handling our protective order first, and then I'll also respond to theirs to hopefully save time and judicial efficiency.
We'll give rebuttal to both parties.
Thank you. I appreciate that, Your Honor. I was going to ask. So first off, let's go ahead and start with the protective order. All right. So Mr. Mortensen filed his protective order. As you know, Your Honor, in the state of Utah, we have a few definitions for how a protective order should enter. We have to have a finding by preponderance of the evidence of either abuse or domestic violence that has been committed. Also, I will cite Patoli versus Marksbury, which is the case that indicates that the fear component is a component, but it's not required. It's an either or, as the court's well aware. In this case, actually, it's, I believe, rather simple, Your Honor. As the guardian ad litem has previously filed, we have an aggravated assault charge and plea of guilty by Ms. Paul against my client. That's domestic violence as specified exactly by the code, as it's one of the underlying sections. Aggravated assault under 765103 is domestic violence.
This is the 2023 incident.
This is the 2023 incident. And I would need at this point to cite the statute, Your Honor, which is 78B-7-608, that the court cannot deny a protective order solely based on a lapse of time. That being said, we've provided other evidence as well, Your Honor, of this cycle continuing. If you turn to our exhibits, we've presented at this point 9 exhibits, of one being the actual incident and others being additional incidents that have occurred since the 2023. I did have one rebuttal exhibit, but I'll get to that later, of a little previous to 2023, the February incident, but I don't need to address that now. As you can see, Exhibit 1 is the actual recording of that incident that resulted in the charges. Then we have Exhibit 2, which is an incident that occurred, and the video we provided shows Ms. Paul striking Ms.
I viewed them both. I viewed them.
You viewed them all. I just wanted to run them through for the sake of the record. And then Exhibit 3, of course, was a picture of abrasions on an assault that he claimed occurred on that day, and he would testify to the same. I'd proffer. One thing I wanted to point out about that, Your Honor, is that was August 3rd, 2023. That was the day she pled guilty to the assault under a plea in abeyance. So I think that's interesting that we still had an incident that night. Exhibit 4, again, more scratches of a separate incident. Exhibit 5, again, and this is an audio recording because my client's recording device was in his pocket, not showing. It does show at least a strike of some sort on the door, which, you know, is a form of domestic violence if it breaks, but also you can hear kind of the anger in what we have there. Exhibit 6, we have an audio and video recording of, again, another assault that happened on October 15th, 2024. Exhibit 7, we have an injury that occurred. You can see the injury to his nose. This is the one we had to fix, I believe, Your Honor, on the date. This one's 2023. Exhibit 8, we have another video and audio recording of the May 27th incident. So this is the one that we've been kind of back and forth with the pleadings, as you can tell. I'll get into that a little more when I respond to that, since that seems to be the main issue that Ms. Paul has in terms of alleging violence with him. Then we have the October 16th, 2025 incident that we also recorded. Oh, this is the one where he had his phone in his pocket. And then we also presented, of course, Exhibit 11, which unfortunately there was no recordings of the most recent incident. We're going to call it the February 22nd to 23rd incident because there's actually two events that happened, both separate on those times. This is the most recent, 2026.
Are the pictures that she provided for bruising from a different date?
Yes, my understanding is that was from the May 2025 incident.
Okay.
That's the one that I think is the greatest dispute.
Okay.
So from that, I did want to show you Exhibit 11, Your Honor. I know you've listened to it, but that's the recording of a phone call that occurred between Ms. Paul and Mr. Mortensen about a day or two after the most recent incident in February.
Is this the one where it was it was represented she was screaming on the phone? Is this?
There was some screaming, yes, but what was really important was the statements that were made by Ms. Paul during that.
Okay.
For example, at the second, just to help the court when you're looking at it, on timestamp number 2, my client asked, well, why did you attack me? And second 8, Ms. Paul responds, I already told them that. And them, if you listen to the context, was CPS at the time, Child Protective Services. I already told them that, yes. Or yeah, was actually the appropriate quote. But here's where I wanted to really get into. And that was later on, about a minute later in the call, he says, well, I've got to tell the truth. And the response was that it will ruin your life, is what she told him. And then at 1 minute and 52 seconds in, you are never working again. And so that's why, Your Honor, I wanted to explain to the court why my client has multiple incidents of this, continues the cycle. And as you can see from the text message and other things we've submitted.
How are those statements pertinent to his request for a protective order?
Because they show, really, it's just a first step to show the court why, as you might be wondering, why has he put up with this? Why has he waited so long to do anything? The answer is he was afraid of the force that would happen against him. That's why. If the court doesn't think that's relevant, I'm happy to skip it, but I thought that that might be the first question of why did this take so long? Why did he wait from 2023 until now? And the incident is because, I mean, unfortunately, and I don't get to say this very often with male victims, but he's a domestic violence victim, Your Honor. He is coerced either through romantic interest or interest involving his son, and with very charismatic texts and very charismatic personality to come back and rejoin this romantic relationship until it blows up again. He's subjected to abuse by Ms. Paul. He then goes back and kind of says, okay, I'm going to stop it, and then comes forward.
But if I understand your argument, you're saying it wasn't until she threatened to interfere with his work life that's what prompted him to file for a protective order?
He filed actually because of the most recent incident when he decided to break the cycle.
All right.
I'm just showing the audio to say why he was afraid to do it sooner. That's
okay. All right.
So that being said, Your Honor, I think there's clearly sufficient evidence under preponderance of evidence, especially with the charge and the plea of guilty, to definitely show that there's been subject to domestic violence. I don't think that's in many ways a difficult argument in terms of him granting a protective order under the statute. However, we have a competing protective order. So let's talk about that. We'll get into the response here, Your Honor.
Well, I want to hear Mr. Swinner make his case in chief first before we get into the response.
I'm happy to do that. Didn't know how you wanted to handle it, Your Honor.
All right.
So, but I'm happy to respond to that once we're ready.
All right. Very good. And let me just ask too, Mr. McDonald, I don't know how much input you have as to whether the protective order itself should enter or whether it's more pertinent to the parent time issue.
I don't intend to argue whether either protective order should enter. I just plan to address parent
Okay.
time.
All right. Thank you.
Thank you.
All right, Mr. Swinyer.
Thank you. May I approach, Your Honor?
Please.
Some hard copies for you that counsel has.
Is this from the thumb drive that I've already received from you?
Yeah.
Something new that I haven't seen before?
Everything has been filed and provided to counsel already.
All right.
We have not submitted a thumb drive. That would be from Mr. Mortensen's side.
Okay.
So if I understand.
That's right. It was from him. That's right.
I just want to make sure that I've got the sequence down correctly in terms of how you want to proceed. My plan was to rebut their request for a protective order and then also drift into my client's request.
Exactly.
Okay, perfect. Well, let me start with, I think, the primary incident, Dakota's Exhibit 1. We can call this the Barstool incident from 2023. My client has zero excuses for this. It's self-evident that something happened. It should not have happened. It is a tragedy that Dakota and my client's daughter were the victims of her actions. She entered a plea in abeyance for assault on Dakota. She's on track to complete her probation in a few months' time, I believe in August. Don't have excuses for this, but there is a little bit of context to add to this incident. This was a very difficult time in their relationship. They were going through some challenges, of course, compounded by the fact that my client was dealing with 2 recent miscarriages. Alcohol was also a massive factor in the 2023 incident, a factor that is no longer an issue. She has not consumed alcohol. As for Exhibit 2, I think this is an important exhibit as well. This is a video that depicts my client slapping Dakota while they were in an argument in her home. Now, my client understands she should not have hit Dakota. The court can take note of that. It's relevant evidence. We understand that. The video also shows some conduct on Dakota's part that I find concerning. Immediately before she slapped him, he took multiple steps toward him, physically squaring up to her.
Toward her?
Toward her, yes. Emphasizing the extreme size and strength disparity of this case. I don't know how big Dakota is. I've heard he's about my size, give or take. When I stand next to Taylor, I feel like a monster. I feel like a giant.
Well, she didn't retreat, right?
She did not retreat. That is correct. But she responded how a lot of folks would. She felt threatened if you get in her face like this. He tells her, hit me. And she did, unfortunately. After she slapped him, he berated her while laughing in her face, telling her to shut up. You're toxic as shit. You're fucked. I hate you, and I hate you more than anyone. It's an ugly encounter between these 2 parties. I think both acted inappropriately. And so I think the court can take some note of that context here. The court was particularly concerned at the April 7th hearing regarding the May 27th, 2025 pushing video, where my client, it depicts her unsuccessfully, I'd say, pushing him out of her home. Now, as she stated in argument on the 7th, as she's repeated and reiterated in her declaration submitted yesterday, she should not have pushed him. The court is justified in being even more concerned about this by the fact that Dakota was holding their son. She acknowledges that. Leading up to this incident, so as you know, Your Honor, it's a brief video. Clearly, there's something going on before the video that resulted in this. And there's also additional context afterward, once Dakota stopped recording. Leading up to the incident, in the days leading up to the incident, Ever had been very ill. And that's their 2-year-old son. Ever had been very ill, and they were having a hard time getting on the same page about how to treat him, how to help him. She feels that leading up to this and during these discussions, he blew her off when she was trying to bring him up to speed. This created a lot of frustration, a lot of tension in the room, so to speak. He came to her house for an exchange right before the video starts. Tempers flared, and she demanded that he leave her home. He did not. This is a familiar pattern in this case. The video picks up with her yelling at him and demanding that he leave. He doesn't. He decides to tell her no, and he lectures her. She then attempts to push him out of the house again while she's holding Ever. Right before he stops recording, she loses her footing and he calls her a fucking bitch. At that point, the recording ends, but what transpires is extremely important for the court to consider as well. And this is rebuttal information, but also something that we would believe give ground to something that we believe would constitute grounds for a protective order in Taylor's favor. She falls to the ground, falls to the floor in her home, and Dakota kicks her multiple times, primarily on the leg. Our Exhibit A, and this is a brief correction, Your Honor.
The May 25 incident.
This is May, yes. There are other pictures that you'll see of injuries to Taylor. Those came in the aftermath of the February. In there, yes. So I'll walk you through
Or
this.
the
but,
ones that were attached to her petition.
Yes. So both. Exhibit A is exclusively related to May 2025. And so I can walk you through those.
I've seen them.
Okay,
The
you've seen
question I
them.
had was, there was reference to a gushing bloody nose, but I didn't
Different,
see
yeah,
any
different
photos
incident.
about that.
Yep. So that's February. We'll get to that in just a moment. So Exhibit A, as you can tell, this is multiple pictures, I think 5 or 6 pictures depicting significant bruising on her leg and wrist, all over her leg, shin, knee, front, as well as the side of her thigh. Understandably, she was still fuming about this incident the next day.
Well, how's she representing that she sustained those injuries?
While she was on the floor after losing her footing, she was kicked several times by Dakota.
Okay, all right.
The next day.
After the video had
Exactly.
stopped.
Yep. The next day, she's still upset about this, and they're tense in their parenting communications, having some challenges here. So she demanded an apology from him. This is in our Exhibit J.
Mhm.
She demands that, this is halfway down the page, you apologize for kicking me while I'm down on the floor. His response is, not in a million years after what you did to me and my son.
Are you saying that's an admission that he kicked her?
Yes. It's a tacit admission. He does not use the words, I, Dakota Mortensen, kicked you, Taylor Paul, multiple times on May 27, 2025. But this was the day after. She clearly confronts him with this allegation. You kicked me while I was on the floor. And he passes by. And he just tacitly acknowledges the allegation. At the previous hearing, I commented, maybe optimistically, I commented that both sides probably wish they could have taken this one back and approached their actions and conduct a little bit different as it relates to May 27th, 2025. But I was wrong. From Dakota's declaration, his arguments, including the declaration he submitted 2 days ago, he describes a story in which he did nothing wrong. We believe the evidence contradicts this. The closest he comes is an allegation that's not in the video, actually, where he grabs her arm, grabs her wrist to remove it from his shirt. And that's how she got, that explains one of the bruises. And his explanation is, well, she bruised herself by spinning around on the floor, which again, I don't think is credible under the circumstances with the extent of the bruising, as well as this text message in which he, could have refuted this. Related to some of the pictures that he submitted, I mean, these are obviously very difficult for us to respond to, Your Honor. They're in some cases several years old, provided with minimal context, not submitted along with the initial request for a protective order. It's obviously a lot easier for us to respond to the video that he submitted, the videos that he has submitted. But we would just point out that she disputes the injuries that are sustained, that are depicted in these various pictures in Dakota's exhibits.
Disputing them in what way?
She has it would be foundational, and she has no knowledge of the incidents.
Of the injuries?
Exactly. Depicted in the photographs. In most cases being quite old. So naturally she'll have difficulty responding. Exhibit 9 is an interesting video. It depicts Dakota and Taylor getting into an argument in her home while he's with Ever, I believe picking Ever up, spending some time with him in his room. They get into an argument and Dakota starts the recording, has it in his pocket. They get into one of these verbal arguments. She tells him to leave. He does eventually. She entered the room, did not kick the door down, as he alleges. He tried in the video, as you'll hear, he tried to get her to admit, you just kicked the door down. And she does say, okay, but it's very curt, very abrupt in an effort to disengage and get him out of the home. Like, okay, Dakota, just shut up and get out of the house. That's how I interpret the tone of the response. It's not an actual admission of, I kicked this door down. I want to draw the court's attention as we transition now into the events of February of 2026. I want to draw the court's attention to our Exhibit I, This is the police report. A lot of interest raised by the court, understandably, at the April 7th hearing about the status of the police report. Where is it? Do we have it? What are the investigators going to do? Are prosecutors going to file charges against any of these folks? Great. And that makes it easy for me. I'll just cut right down to the chase with the police report. We submitted this as our exhibit yesterday morning. As the court has already seen, pages 3 through 17 of the police report contain the meat of the investigation, of the findings. And you'll see they did their due diligence. They kicked over a lot of rocks here. There's multiple verbal and written statements from both parties. Both parties submitted pictures. Dakota submitted some videos. As I interpret it, it's largely the same body of evidence as what's been provided in the respective protective order matters. Very large degree of overlap. And this, importantly, is centered on the allegations that took place on February 22nd and 23rd. And in all candor, I think it is helpful. You've already read this, Your Honor, so this won't be...
You can read relevant passages if you want me to.
Sure.
If you want to highlight those.
I'm just looking at one that kind of encapsulates what happened, because obviously as outsiders of the investigation looking in, you always kind of wonder, you'd like investigators, prosecutors to kind of show their work, provide their analysis as to their findings. And on page 16, the city prosecutor, this is the investigator's recitation of the prosecutor's analysis on the case. And I'm reading this to be candid, Your Honor. This cuts both ways. This is a mixed bag for both parties. It certainly doesn't completely absolve my client. I understand that, but I do think it is relevant. So I wanted to just read it briefly. It says on March 20th, 2026, the city prosecutor provided me, this is the investigator speaking, with an analysis on the case. She advised that neither Taylor or Dakota are credible witnesses, with both their statements being fraught with inconsistencies, such as Dakota's statement to 911 and Taylor saying she had a bloody nose with no evidence of that being true. That Taylor most likely injured Dakota on February 22nd, ripping off his necklace and causing the injuries she sustained. In causing the scratch to his neck in the process. Dakota causing injuries to Taylor on 223 while in the truck, because the injuries she sustained do not fit him pushing her off of him. The injuries are more consistent with him grabbing her head or neck and shoving her head against the dash, and that both parties are misrepresenting their behavior. Also, Dakota had told her that he had not spoken to DCFS, and when she had spoken with DCFS, they confirmed they had spoken to him multiple times. They then conclude that DCFS might be the best way to help these folks.
There's no criminal charges, either way.
Either way.
At least at this point.
City or county, no criminal charges against either party.
The DCFS investigation is still ongoing?
No, it's completed.
All right.
And I'll give a full update on DCFS in just a moment, Your Honor, because I think that's an important point. So we mentioned bruising. Exhibit A, as I mentioned, relates to the May 27th incident. There are a few. This is an overlap with my clients. It is our Exhibit E. If we look at pages 25 through 27 of the police report, you'll see the bruising. You'll see a compilation of the bruising that's referenced there. Page 25 is the large bruise and swelling on her forehead.
Same pictures that were attached to the petition, right?
There is one different one. There is one additional one that I can show you. That would be on page 26
of the
police report.
What's the exhibit number?
That would be Exhibit I, Your Honor.
How far into it? It's a long exhibit.
Right, it's numbered. I'm looking at page 26.
Okay, 26 of 34, where
yes.
She's wearing a red.
Yeah, and you can see the bruising on her shoulder. This is her left shoulder.
Okay.
So see how these pictures tie together. So we go to Dakota's allegation.
This is still from May, right? May of...
No, this is related to the February 23rd incident.
Oh, I see. The one where you said we didn't have any videos of.
Correct.
Right.
Correct. So this sequence of pictures, again, relating to February 23rd in the truck, neither party, there were no other parties present, no recordings, no audio recordings.
This began in the house, right? And they moved out to
Yes.
the truck. The child was
Yes.
sleeping at the time.
Yes.
Okay.
So they were intimate in the home on the 23rd, and then
This was at her place, right?
her place in Draper. Dakota wanted to talk about the relationship, knowing the volatility and where these often go, with folks getting very animated, yelling at each other. Taylor acquiesced on the condition that they go outside. So they went outside. Dakota drove away against her wishes with her in the car and then assaulted her. And this 3 pictures,
Away from the house with the child alone inside the house?
Correct.
At 2 years old?
Yes. So
how far away?
Well, as he tells it, he kind of did a loop. So he stayed in the vicinity,
Okay.
but drove away against her wishes. The reason these pictures are important is because what happened, right? You've got 2 different narratives here that are at odds. We're in the truck on the 23rd, and they're both pointing their fingers at each other as far as, hey, they assaulted me. These pictures were extremely relevant and persuasive to law enforcement because Dakota's narrative is she went crazy and I had to kind of fight her off of me. And in that scenario, in that sequence, yeah, I did, push her head against the dashboard. He admits that in writing to police, but it's within that context of it's defensive. But the prosecutor and
have we shifted from response to his petition to initial argument on hers?
Yes.
All right. Okay.
If that's okay.
That's fine.
Okay. All right. And it's a bit of both. I mean, if both sides are claiming assault as it relates to February 23rd, there's going to be some bleeding over. So.
Okay. All right.
Okay. So with that clarification, Your Honor, again, investigators and prosecutors looked at this sequence of pictures provided by Taylor, and they contradict what Dakota said about what happened on the 23rd. These are not defensive bruises that Dakota inflicted on her. These are bruises that depict her left shoulder. So again, she's sitting in the passenger seat. These depict him forcefully grabbing her shoulder and sending her right into the dashboard. There's also a picture of bruising on her arm, which occurred during the same incident when he struck her. Now, again, we've switched gears a bit and kind of drifting into my client's request for a protective order. As it relates to Dakota's conduct, my client has seen patterns of abuse and isolation, harassment over the years. And she would like to highlight just a couple of things that kind of speak to his inclinations, speak to what his desires are for her, his possessive nature. We have submitted as our exhibits B and K a very small glimpse into his obsession over Taylor, his inability to move on and leave her alone. Perhaps the strangest exhibit of the hearing will be our exhibit C. It's a 3-page sequence of pictures that depict a tattoo that Dakota received on the inside of his lip, his lower lip, of Taylor's initials. This was done without her knowledge, without her permission, and during an extremely difficult time in their relationship. It was unwelcome. She told him that. As soon as she found out about the tattoo, she told him that, labeled it creepy, and he just doubled down on it and denied that there would be anything objectionable about it. Dakota does attempt to muddy the waters. In his statement filed this week, he does attempt to muddy the waters on this issue. He attaches a text message in which they claim, Taylor implies that she liked the tattoo, finding it quote unquote hot that he had the tattoo. That is not a fair reading of the text message. It's clear that she's mocking him for having the tattoo. She's essentially telling him, I'll be thinking of your silly tattoo while I'm with other guys. It wasn't nice that she said that, but that is the context, and that is the correct interpretation of what she was attempting to convey, not meant as a dig at him. It was meant as a dig at him, not a genuine expression. Another objection my client has regarding Dakota's conduct over the years that, again, shows his infatuation with her, inability to let go, his monitoring of her, is shown in our Exhibit K. This is at the very end of our exhibit packet, Your Honor. Very briefly, this demonstrates that there are two instances. There were two instances in which Dakota stole Taylor's phone. Specifically, if you read these, specifically...
This is him talking in this text bubble, in these text bubbles.
Yes. And so, for example, if you go... So, Exhibit K, pages 8 and 9. If you go to the second to last page in this exhibit, that is page 8. What's being shown here is the first instance, did you steal my phone? So weird, and she confronts him about it, and he downplays it. The second instance is depicted on the final page here. You stole my phone again? He says, yep, wanted to read all the messages of you and Braden. She says, dude, you're a creep and it's illegal to be stealing from me. And his dismissive response was, oh, call the cops. So he didn't understand that he had crossed a boundary, that this was invasive, that it was, at a minimum, improper for him to be observing and intruding on these communications that he imagined she was having. Finally, Your Honor, I do want to, as it relates to his abusive conduct, I do want to touch on something that is a little unusual about this case. There are a few aspects to it that are a bit unusual, but this is one that my client and I find, I think, relevant, and that is a very public leak of the 2023 Barstool incident to media outlets, one specific media outlet, TMZ, on the same day that Dakota filed his amended request.
You're
for a
talking
protective
about
order.
the affidavit from Draper.
Yes.
Okay.
Yes, she touches on that. Yes. So you're correct that a declaration from Jesse Draper was filed yesterday afternoon.
Okay.
And so I'll get to that in just a moment, but to provide a little bit of context, last year, my client, she was announced as ABC's Bachelorette. Filming took place in the fall. The season was supposed to have debuted on March 22nd. However, on March 19th, the same day he filed his amended request for a protective order, a news outlet published the video of this incident. Before this release, it had not been out in the public. So this was released 3 days before the big debut and coincided, again, with other actions he was taking with the protective order, as well as coordination, additional reports to law enforcement. I understand he denies having done this, but a lot of information lends itself to Dakota leaking this, or at least at a very minimum, having his fingerprints all over this. In addition to the timing, which is extremely coincidental, the declaration of Jesse Draper, which you alluded to, Your Honor, indicates that in the days leading up to the March leak, Ms. Draper entered the basement of her home, that's Ms. Draper's home, to find Dakota speaking with Ms. Draper's husband, Jordan, as well as Dakota's roommate, Crew. And what they were talking about, she noticed that he was very animated, that Dakota was very animated. He was venting his frustrations with cops not doing anything, and told her he was going to take matters into his own hands to embarrass Taylor. He specifically told Ms. Draper that he planned on leaking embarrassing videos of Taylor to the press, starting with the Barstool video. He specifically named TMZ as the outlet, and a few days later, that exact video was released by TMZ. My point in bringing this up, Your Honor, is that it contradicts how he is attempting to portray himself today as someone who is really he does not want to come after her for custody. Excuse me, Your Honor. So our point with the video is he's not just trying to come after her for custody. He's not just trying to seek a protective order. He wants to literally destroy her. He wants to subject her and her family to a new round of torment. Yes, there are career implications to it. There's mass embarrassment associated with that. But ultimately, our big problem with that, my client's big objection to his conduct was, this additional harm and embarrassment and shame that he inflicted on my client as well as her children. This was a step too far, and we think shows his true nature.
All right.
I do have comments on custody, but I'm guessing you want me to hold off on those for the time being.
Just for now.
Okay.
We'll come back to it.
Great. Thank you, Your Honor.
All right. Rebuttal and response.
Rebuttal and response, yes.
Right. And then when we get to the parent time issues, I'm going to start with Mr. McDonald, then we'll work our way around.
Sounds reasonable, Your Honor. Okay, so let's take a look at, we'll do response first, as I think that will kind of square up, and then I'll rebuttal for kind of the entirety for that. So I see 4 allegations in her protective order against my client. I'll go through them line by line, Your Honor. The first one, and you've seen our declaration opposition with its exhibits. I'll try not to burden the court by reading it directly. Regarding the May 27th, 2025 assault, as you can see from our declaration, my client reports it was actually stricken before he turned the camera on. Once the camera's on, you can see her acting extremely violent against him. When he was able to turn the camera off, remember he was holding his son. She was grabbing him. You see the information that we have here. We suspect her injuries were occurred from her.
I'm more interested in his explanation for her injuries.
So the wrist is likely because he had only one arm as holding the kid to try to get her arm off because he was trying to get out. She tripped. And I think the tripping and the kicking on the floor is likely where the bruises to her legs happened. He does not believe he ever kicked her at that point in time. And I do have some interesting bit about that.
He doesn't believe?
Well, yeah, he was being assaulted. So it's
All
a little
right.
hard to figure out exactly where things were, but he does not, he will definitely, if I called him to testify, I would testify he did not intentionally kick her in any way. But when you have someone falling on top of you and you're trying to get away and you're trying to hold your son, legs can kick out, you can fall backwards. He was trying to hold his balance. He
Did
stepped
the
on a
video
toy.
shoy him falling down?
No, the video stopped before that. That's the unfortunate.
He was able to turn it off while he's falling?
No. He did not fall. He started to fall as he fell on the toy, tripped on the toy. And that's when he realized, okay, I've got to get my hand. So he turned it off. So
All right.
that's what he says. And I think that makes a lot of sense, Your Honor. What I think is really interesting about that is the rebuttal exhibit that I did cite, Your Honor, is she indicates in the exhibit, I believe it's rebuttal exhibit 4, there's a text message stream where she actually indicates, and this is from a year, May a year ago, that she has her video of the incident and he has his. What I think is interesting about that, we've never seen her video, which leads me to believe she was either being untruthful and she never filmed it, or she did have a film and she's not showing it for a reason. And that's what I think is important, Your Honor. It does go to credibility. We're in a preponderance suit here. I do think that that's important to recognize. I also, really want to put this in perspective. He is holding his kid at the time. He's trying his best to leave the residence. And so that's where we're at. Also, as you can see here, let's move on to the next one. I did want to address the police report really quickly, Your Honor, before I forget, because it's not detailed here. And that is, remember, police are always looking at beyond a reasonable doubt. It's a different standard of proof. These injuries, that was photographed, there is no, kind of nothing but her testimony or her statements that they were inflicted by him. And there's nothing but his statements as well. This is not
the February incident.
This is the February incident. There's nothing, no one recorded, everything was done after the fact when police were called later. And that's the problem. And it was like, I think 2 or 3 days
What's odd to
later.
me is that from May of 2025, there's video and photographic evidence, but no charges either way.
I know, Your Honor. It's a little odd too.
Very
And
odd.
I'm a little surprised as well, especially since Ms. Paul was under court probation at that time. Or not just court, I think, well, I might have the date wrong, correct me if I'm wrong, but she was under AP&P probation for one period of time and then it went to court probation. So the fact that that didn't come forward, it's why I mentioned earlier, Your Honor, that stuff about him not coming forward. It's because I think that's the oddity, is why doesn't he tell the DA? Why doesn't he do these things? Because he was afraid.
Okay.
And so now let's head over to the February 22nd incident. You've seen our response, Your Honor. We see text messages. She indicates in her protective order that he was harassing her and trying to come over and trying to hook up. The text messages that I submitted, extremely clear. She invited him, and she invited him for the sole purpose of intimacy. And I think that's extremely why we keep seeing this cycle happening. And he did go over.
I just have to back up. I mean, they entered into this stipulation for 50-50 custody in June of 25.
I'm
right?
aware.
after this all happened.
Yes, I'm aware.
Okay.
And that's part of the problem, Your Honor, and I'll get to custody in a second,
We'll
but
get
that's
to it,
why I
yeah.
mentioned those issues, is that this is a man who I would expect a lot of male domestic violence victims is he's trying to make things work. He's trying for the sake of his kid. And he's still enticed. He still has this spark of romantic relationship that occurs, but then it's a cycle. Then it breaks down. Then there's an assault. Then there's a, kind of a, oh, I'm sorry, here we go. And you can see, like, for example, perfect case scenario on the 22nd incident when we're talking about the broken necklace. You actually submitted the text where she said, I bought you another necklace. Well, I can quote it, but I bought you another necklace for the 1,000th time.
All right. Okay.
1,000th time. That's a pretty good statement. These are being ripped off a lot. And he can find the information he can, but, and the pictures he can, but that's where we are. He gives a pretty good incident. I mean, you can see on the 22nd, that was the thing. She jumped on top, strangled him, pulled his necklace, broke it off. We have the text messages that support that. And then we have again, well, that one I do want to mention. He did call 911 that night. That was the first inkling because he realized he looked over at his son, saw his son terrified and crying and went, I can't do this anymore. I can't do it. I've got to take it. I can take it. My kid can't.
Are we
February
leading
22nd.
into 26 now?
February 22nd, 2026.
One where we don't have any.
No video.
No video.
Okay. And in that incident, he does call 911. And he regrettably, she said, please don't, please don't. And so he makes something up and says, oh, we're wondering if the kid's sick, because the kid was sick earlier that day. So it's not a lie, but he chickened out. He didn't tell police I've been assaulted. He didn't want to face that wrath. And so he left. The next day, February 23rd, it's the next day, early morning. You can see the text message we provided. She entices him again, specifically saying, come over here. I need intimacy. I'm paraphrasing it in a nice way because we have cameras, but it's not that nice in the text.
Similar kind of behavior himself.
Yes.
In that regard.
Yeah, there is some of that as well. Yes, of course. But, requesting or having, sexting back and forth is not grounds for a protective order. But in this case, I'm presenting it because it conflicts with her narrative that he's this stalker that is somehow always hitting her up or going there. She specifically requests it. He specifically goes on the 23rd. They have a whole discussion about where they're going to be able to do it because it has to be downstairs because the kids are there and they're sleeping and this and that and this. And they go down there and the same thing happens. But this time, she throws things at him. She throws his phone, breaks into the wall. It like sticks into the drywall and he had to pull it out. It's probably why he didn't record. And then he runs out to the truck. And while he runs out to the truck, she follows him. And she was trying to block him from leaving the residence. It's not the actions of someone who's...
So here I just have stories, right?
This is just stories. Yeah. We just have their story and our story.
Proffers of testimony.
Proffers of testimony. And he says that she...
Except maybe for the one exhibit that she said occurred from what transpired in the truck, right?
Yeah, well, we have the police report, but their statements pretty much follow exactly what we're saying here, Your Honor, which is he says that, and it's my client, that, and I think if you look at the history of this case, it's the more credible retelling, that she follows him out. She blocks him by getting in his passenger vehicle so he can't leave because he says, this is it, I'm calling police, I'm done, okay? She doesn't want that to happen. She follows him because she has got a lot on the line. She follows him, gets in the car. This has happened before, he would testify. He's like, I don't know what to do. She sees a text message come through or a phone call come through from some girl that he's seen. She starts kicking and busting the video screen thing that we have, in our trucks or our cameras in our cars. She didn't break it, but she was hitting it. Then she starts, striking him. He's like, well, I better, try to get out of here. So he starts driving. He starts driving around the block. Hopefully she'll calm down because he's good at calming her down usually.
And this is all led to the police report.
This does.
That said that concluded they both had credibility issues, right?
That's correct, Your Honor. The police report believed that. I don't think my client has credibility issues, but I think when the DA's office is looking at it, they're going to make a call, and I would humbly suggest that they didn't want to get involved in this. So they said it both ways. But credibility for her, I mean, we've got preponderance here, Your Honor. The next up is just to cover it. She started interfering while he was driving by squeezing his face, that's why he throws her off of her. And that's where I need to cite a statute, Your Honor. And I think that's the important thing for this case.
You have photographs from that incident?
No. Well, I mean, later. with the police. They took the necklace and stuff like
Right,
that.
right,
But
right, right. That's right.
squeezing the face, I mean, it didn't.
I haven't
leave
seen
any
those,
marks.
have I?
The necklace photos were in our original exhibits.
In your
Your
original
the scratches, yeah. But here's what's important. I think we need to quote here. Section 78B 7108, mutual protective orders. I don't get to refer to this statute very often. When two parties have filed protective orders, the court may not grant a mutual order or a mutual civil protective order to opposing parties unless each one's filed their own. That's happened. And there's a showing that, there's basis for it. But it becomes the party's burden, including Ms. Paul's burden, to demonstrate that the abuse or domestic violence she's claiming did not occur in self-defense. We're saying it's self-defense, Your Honor. He had to stop the attack. He did push her off. It's possible she got a bruise to her head. He didn't see anything. He didn't see a bloody nose. She said her bloody nose. He went back the next day. There's no bloody nose. She's not saying anything. It's in the text messages. We think the credibility there is, it's very easy for her to, if she's attacking him, to harm herself or to get hurt by hitting him. It's very easy for her to push. He is stronger, and she gets thrown into the door as he's trying not to crash the car where the kids are at home alone. So he goes there, he pulls off, she gets out, and here's what's interesting. Okay, and this is why I struggle with the credibility of Ms. Paul's statements. That right after that happened, she proceeded to call him 11 times, and we submitted those phone logs. You can see them 11 times. And in the very first one of the calls, he would say, because it's not recorded, it's called, she actually says that phrase that she then used later to say he's this harasser, so you don't want to fuck. That's what she said in the first call after this whole thing happened. That's what she says. And which he was like, what are you talking about? He said no. He gets 10 more calls from her. It's in the phone logs. We submitted them. Saying that they should return. She then says she has a bloody nose. He's concerned, so he goes there because she says, again, using the kids, I need to go to the ER. Someone has to watch the kids. He goes, tries to get in, knock on the door. She won't. Sees through the window. She's there. There's no bloody nose. And so he leaves. And you see the text messages that we provided. You can hate me. It's valid, she says. He says, finally, the intimate relationship's over. And we submitted those text messages. I think it's really important that he's finally had the courage to break this cycle, Your Honor. But I need to respond to a couple other things as well. So next up, here it is. Harassment. She claims that there's been harassment in this case. I do need to cite what the definition of harassment is, Your Honor. Harassment, as defined by, and the Protective Order Code does reference this, 76-5-106, which is the criminal code for harassment. An actor commits harassment if, with an intent to frighten or harass another, the actor communicates a written or recorded threat to commit a felony. There's no evidence of that here, Your Honor. That's not harassment. It's not a basis for a protective order. February 23rd, we've covered. February 14th, the harassment and stalking. Again, for stalking, Your Honor, I need to cite Meyer v. Potion, a case I'm sure you're familiar with. In that case, it talked about the reasonable person standard. It's not whether she feels it's stalking harassment, Your Honor. It's what a reasonable person would believe. And falling into that, when we look at it from an objective standard, the one piece of evidence she really draws on is this tattoo. Okay? And, and just because I forgot about it, but in Exhibit 10, which happened right after the incident, the 23rd, we showed you the phone logs. She made 151 phone call attempts to him between 2 hours. It's not the behavior of someone who's afraid and worried that she's been abused. It's the behavior of someone that's afraid that the abuse is going to come out. So February, it sounds bad. When I first heard about this tattoo thing, I went, geez, Dakota, what are you doing tattooing something on the inner of your lip? And he gave me an explanation I wasn't prepared for. Makes a lot of sense. It was a filmed segment of the TV show, Your Honor. All the dads decided to go down to the tattoo parlor as part of the Secret Lives TV show. It was filmed. It hasn't been released yet. They all get tattoos, and they all think, oh, it'd be so funny if you put Taylor's initials in your inner lip. And it's something else I didn't know until I looked into this. Inner lip tattoos, the reason why people do that is they fade. They are not permanent. They go away.
I have no idea whether that's accurate. And I don't have any
I will
expert
proffer my client's
testimony to that.
testimony. In fact, if you want,
One way or the other.
it's not really there anymore.
All right.
So That's why. So it's not something that shows or permanently affects the bodies. What I think is really important with that is he was there with the group. It was filmed. When it comes out, we'll probably all see it. And what's important with that is, more important is that you could absolutely see in the messages that we provided, the text messages. Yeah, I mean, they're trying to say she was just horrified by it, but no, she actually talked about how she was, I'll say it's kind of, I mean, I'll soft sell it as a turn on, but my client would proffer his testimony right now that that very night of those text messages that you saw of her allegedly being freaked out about it and thought it was possessive, they were intimate that very night. So this is not a stalking, harassing behavior. These are two people that are on a TV show. They're doing all these different things to kind of make it interesting as TV is. But that's not stalking behavior. That's not harassment behavior. Yes, my client will admit this is an inappropriate relationship. It needs to stop. That's why he filed his protective order. But the main issue here, when you look, and I guess we're doing rebuttal as well. The main issue here that we have is his desire to protect his son. That's why he filed this protective order, is to protect his child, to stop the violence, to make both himself and her not be able to have contact. Now, this is a small thing, 150 days. It's not going to be that long. We've got a lot of work to do in the custody case. We've got DCFS involved. We're going to get to the bottom of this and sort it out and get some help. You've seen the videos, Your Honor. You yourself commented that there were some behaviors that were deeply concerning that we've seen from Ms. Paul when she gets emotional and when she gets aggravated. I definitely wouldn't want to be a child around that, and that's something we can work on. He believes she could be a great mom. She's a great mom when she's not emotional or not under these things. That's the problem. But we believe her protective order, which was filed minutes before the first hearing on April 7th, is not designed to protect her son. It's designed to protect her image. And her image has a lot of value. And so that's our argument in terms of credibility. I also did bring, I can proffer the witness, Your Honor. I don't think it's relevant about this going downstairs and the witness hears them talking about whether he's going to release the video or not. February 23rd video. We have a lot of February 23rds. The 2023 video, how about that? The one with the chair video. I don't think it matters from a legal standpoint whether or not he releases it or not. That's not a basis for a protective order. But just to show the credibility issues, he denies doing that, Your Honor. In fact, he told his publicist not to release the video. And I do have, Your Honor, someone who was downstairs with him, and that would be Mr. Crew Eaton, who's present, and I could proffer his testimony.
I read what in the police report. Apparently, he's the one that called the police, right?
Oh, the roommate? That's someone different.
Crew Eaton, he was the one.
Oh, no, the same person. Yeah. But Crew was down there at the time, and if I point to him, and he can correct me if I'm wrong, he would say that Dakota actually kept saying he didn't want to release it. Didn't want to release the tape. Like I said, not terribly relevant. Exactly. So, Your Honor, I'm happy to talk about custody if you'd like to hear from that. You said you wanted to hear from the GAL first, but that's where we're at, Your Honor.
All right, I still need to give Mr. Swinyard the opportunity for rebuttal on Taylor's request for a protective order.
And after rebuttal, you'd still like me to sit tight on custody before we drift into that?
Yeah.
Okay. Understood.
I have the domestic case too, so I don't know where this is all going to lead, to be honest with you. Are we going to keep coming back here periodically for time immemorial? We'll see. Yeah.
Hopefully we can avoid that. You know, the word cycle's been thrown around. A lot of back and forth, a lot of toxicity in this relationship for a few years now. My client, she is taking accountability for her role in that. She's owning not just her participation in that, but the actual misconduct that related to it. We've gone through some of the allegations in the protective order, Mr. Mortensen's request for a protective order, and she's provided some context and some accountability for that. Mr. Mortensen does not own anything. He's not owning up to anything in this case. His strategy is extremely simple: deny everything. His only crime, as he tells it, is to give in to her advances. No mistreatment by him, no abuse, no violence of any kind. My client has shared her version of events regarding her request for a protective order. Again, the May 2025 incident does stand out. We got an interesting characterization of it today.
I do want to ask, and just from a credibility standpoint, she was texting him saying her nose was gushing with blood, but there never was a photograph of that.
Well, let's just keep the sequence straight. That was a different incident, which I'll come to in just a moment. That's
all
yeah.
right.
I know that there's a handful to keep track of here, but the May 2025 incident is her pushing Dakota and Ever out of her home. That's the one I'm referring to right now.
Okay.
All
right.
So again, this one stands out because there is an admission, a text that we believe operates as an admission that he did kick her.
There's photographs too. Yeah.
Photographs of bruising, and counsel's version of events came awfully close. I would say he did acknowledge that his client did kick Taylor while she was on the floor, but there was some
he said he
vagueness.
proffered that if he were to take the stand, he would say he didn't recall kicking her.
Yeah, he may have, right? And then speculated that, well, it would have been a natural response.
And he was being attacked at the time,
Right.
is what his argument is, self-defense.
Exactly.
Yeah.
Yep, I understand the argument. I just don't think it's very credible under these circumstances, especially with the photos of the bruising as well as the text message. The February, now we're skipping ahead to so the one you just mentioned with the bloody nose incident, Your Honor. The February 23rd, 2026 incident. Need to evaluate this and scrutinize this one as well. What the evidence actually shows, despite what he has alleged regarding this, what the evidence demonstrated to investigators, and which we think is more credible, is, again, he assaulted her, violently grabbing her by the shoulder and throwing her into the dashboard.
Okay.
I looked through his declaration from 2 days ago. I don't even think he acknowledges that his force sent her into the dashboard, but he acknowledges that in his written statement to police.
All right.
So he's having a hard time kind of keeping his story straight and providing some context for her injuries. He did, after that incident, he did finally drop her off at her house. He feared, and this is not me speculating, this is what's going on in his head, according to his statements to police. He feared that he injured her. Shoot, maybe she has a bloody nose. And that's why he did not call 911, which I think is curious.
He didn't, but she didn't either.
Right, but what my point is, he's saying, I was about to call 911, but I thought I injured her, so I'm going to go to her house and see if I can contain this chaos, which I think implies guilt on his part. So he returns to.
How long after the incident did she text him saying, "There's blood coming from my nose"? I think in that reference, though, he was asking for a sexual relationship. That's how that preceding that comment that she had made about her nose bleeding. Right?
This was, as I understand it, in the immediate aftermath of that. So minutes after.
All right.
So not hours or days, very soon after.
Okay. All right.
Which I think is curious.
But she took a photo of the arm, the bruise, but not the face. That apparently was.
Yeah, she should have. The bruising, she
I mean, that
thankfully
would be seemingly more compelling, wouldn't it?
I mean, it would be nice to have it today, sure. But I mean, she got around to taking the photos after the bruises developed, and she should have taken a picture of the bloody nose.
Okay. All right. All right.
And again, this is the instance where he claims that she just assaulted him, and yet he goes back and asks for sex. And we'd object as to foundation, as to these call logs. The call logs that have been submitted and evaluated are all over the place, difficult to follow in terms of the dates, the timestamps. Some of these communications show that these are outbound calls from Dakota to Taylor. Some are coming from Taylor to Dakota. And so we don't think that it actually lines up and demonstrates that there's 100 missed calls from her on one of these days. So we believe that these instances, among other things, among his possessive behavior, which we've outlined with some examples in our exhibits, his vindictiveness in terms of trying to, again, go one step ahead of things and ruin her life with the leak. We think that this will be important to have a protective order entered for her. She'll certainly benefit from it, and she's met the grounds for doing so. Do have a couple comments on his protective order as well, Your Honor. She's trying to take accountability, and she has done so in this case related to the bar stool, And
Can I ask a
certainly,
question about that too?
sure.
Didn't she make those same arguments at the time of her criminal sentencing?
Yeah, I
Taking
presume I was
accountability.
not involved in that, so I don't know exactly what statements she would have made.
All right. Okay. All right.
But we believe the court has discretion, certainly, to enter a protective order in Dakota's favor, but it's not mandatory in this particular case. He has shown zero fear of my client whatsoever, which is an element. It's not a silver bullet. I don't know that there is a silver bullet, but it is a relevant element to consider here. You can see it in his expressions and how he communicates to her during even their most heated exchanges. He eggs her on, laughs in her face, insults her relentlessly. You can see this lack of fear in how he pursues her over and over again, love bombing her, manipulating her. Examples of these possessive overtures are included as exhibits B and K in what we've submitted to the court. We can see this in how he's working overtime to completely destroy her. He is obsessed with this woman. He's not in fear of her. Those are different issues. Likewise, the court can and should consider the passage of time of many of these instances. The court understands that you are prevented from only relying on a passage of time, but we still think it's relevant in this particular case. If he was in fear, if he's truly been in fear, trapped in this violent relationship for over 3 years, if he truly considered himself a victim who needed protection, why would he instead just sit behind a camera and just stash embarrassing, difficult moments in their relationship? It's not really in line with what we'd expect, how we would expect a victim to act. And so we are asking for entry of a protective order in her favor and denial of Dakota's protective order, Your Honor.
Okay. I want to switch gears and go to the parent time issues. I want to start with the guardian ad litem and see where we go from there. Okay.
And Your Honor, I'll be pretty brief. Frankly, since we were here last time, my opinion and recommendation hasn't changed, and it's still based on the same argument that I made previously. I've reviewed all of the new information. I tend to agree with the police report that as you read through everything and look at the evidence, it's difficult to find credibility with these February incidents from either party, frankly. My concern goes back to the initial incident in 2023 that didn't involve my client, who wasn't born at the time, but did involve I guess I can't say petitioner or respondent because they're both petitioners and respondents.
Mother and father.
Yeah, correct. But that incident was alarming to me because of the chair being thrown with the child sitting right there. I know it wasn't intentional it wasn't child abuse in my opinion. She wasn't intending to throw the chair at the child. She was intending to throw the chair.
Direct child abuse, but it certainly was domestic violence in
the
the presence of a child.
Correct. And they charged it as reckless child abuse, but it also, that got dismissed as part of the plea deal. Nonetheless, when you read through the probable cause statement, it's a concern. I mean, they're fighting, the child's sitting right there. You know, domestic violence related child abuse can be a little bit interesting in that sometimes you might have a child in the room next door, but the child's not in like direct harm. In this situation, the child was in direct harm. The child was sitting right there. The chair hit the child in the head. And that didn't stop her. It didn't stop her actions. Again, she pled to the charge. She did the DV assessment as part of her probation. She's complied with probation. She completed, from what I can tell from the probation report, everything that she should have, and she should have learned from that. And then we go back to this May incident, and I understand, and I said this last time, there's a beginning that's not filmed and there's an ending that's not filmed. But what is filmed is Mr. Mortensen holding his son and Miss Paul coming at him and pushing him and pushing him. And I don't think it's the trip incident that has been discussed, because it sounds like that happened after the camera was off. But you can see Mr. Mortensen, you can see the camera go like this, and then it kind of ends. It's clear to me, I mean, that was, again, putting my client at risk of physical harm. If this was a situation where the domestic violence and the fights that had occurred were done in the presence of the child, and the child wasn't specifically in physical risk, or if, you know, there was kind of a wake up when these things happened and it stopped, I might not be recommending supervised parent time, but I am really concerned about, like I said last time, Ms. Paul's ability to control her behaviors in these situations.
Well, I mean, this is the question I have for you,
Yeah.
which is I don't see really that there's any other let's say no criminal matters I could find regarding Dakota, and the only criminal matters that were found had to do with the interactions that they had with each other, and even in the videos too as well. The injuries, it's all these are all relative to interactions the two of them are having with each other. What's the risk in terms of to the children if I'm keeping them both away from each other?
I think the risk is that when you have someone who perpetrates domestic violence or is involved in domestic violence, and there's no sort of learning to control the behavior, I think the risk is that there can be future relationships with other people, that those relationships can lead to domestic violence again. I think that there can be additional fights that happen with other people, but I agree, there's no criminal history there. It's just those two situations were extraordinarily concerning to me because there wasn't that sort of wake-up call when the child was put in harm's way. And again, it's my concern that there's a lack of control there. My thought is that the family is working with the division. They're doing services with the division.
What happened with the case closure on the DCFS investigation?
Supported mom for DVRCA and supported dad for failure to protect.
Oh, they both were supported.
Correct. One for failure to protect, the other one for DVRCA. Okay. So the division is providing services to the family. What I would like what I would like to do, and I understand that the court has the primary custody case also, and so, you know, maybe this isn't the best idea in the world, but what I would like to do is set a review date and come back in about 60 days and see what the progress is on the DCFS cases.
Do we know what services are being,
what
they're doing right now as part of a services plan?
I do. I'm a little bit hesitant to discuss it on the record, but there's going to be some assessments done by both parents and then follow the recommendations of those assessments.
EV assessments?
Yes, and mental health assessments.
Okay. So this is not voluntary. It's
at this point, it's
avoid filing of a child welfare petition.
That's essentially it. So I think that they would call it voluntary because there's not court orders. But I think that there has been discussion of filing child welfare petitions, but for the agreement to do the services.
Well, this isn't juvenile court. I can't take the kids away
Correct.
from both, child away from both of them. And
correct.
Supervise them both, right?
Correct.
But what I think I hear you saying is you're more concerned about her conduct than his, though. I mean, any concern about what you've heard with respect to his conduct? And yeah, I mean, absent her behavior, I mean, there's certainly under certain circumstances, I might consider supervising him as well.
And I understand that too. My biggest concern, well, I'm not going to sit here and say I don't have concerns with his conduct. I mean, I've listened to the audio, I've watched the video. I don't understand from his position how when he's being attacked, rather than booking it out of there, which would probably end things, he pulls out a camera and films it.
Well, I had those same thoughts.
Yeah, that is a concern for me. But his actions, as I see it, he's not throwing chairs that are potentially hitting my client.
Right.
He's holding my client and backing up when he's getting pushed.
There's the difference. I have some thoughts about that too, about the nature of each of their behavior.
Yeah. With that said, I mean, I don't disagree. I mean, it's 2 years that my client has been alive, basically, and he's been exposed to this for that 2 years over and over and over. And Mr. Mortensen has an issue. I mean, that's why they supported him for failure to protect.
Yeah. Yeah. Okay. All right. Okay. All right. Let's go. We'll go back to Mr. Hall. You'll be up next on the parent time issues.
Well, Your Honor, that's why, and I do take issue with it continually saying that Dakota isn't taking, or Mr. Mortensen isn't taking responsibility. That's the responsibility he's taking. He believes he needs to break this cycle of continuing to essentially fail to protect by not withholding, not saying, no, we're not going to come back. I'm not going to take your text messages again. I'm not going to expose my child.
He could have done that way.
He could have.
But he chose instead to file for a protective order.
That was his method of saying, I'm done and we're over and we're going to separate. And I think that's a good way to do it. And we shouldn't blame people for filing protective orders to assist them with that.
Well, your argument, though, was that hers was, in a sense, retaliatory. But
I think there's
some evidence there that, you know, in terms of her bruising as well, passage of time. in one sense, you're arguing we shouldn't be dismissing his request due to the passage of time, but you were suggesting maybe I should with respect to her.
No, hers, the most recent thing, we're saying it's just not credible. It doesn't rise to the level of domestic violence or abuse, Your Honor, what she is saying he's done to her. He's trying to defend himself and leave. We have ample evidence presented that she has committed domestic violence and abused him. So we only need one protective order to keep this running. And his is to protect, we only need one to separate the two and do this. If he violates the terms of the protective order, I know it's not a criminal violation, then she can say, well, you're back here again. And trust me, the division won't like that either. But in terms of custody, Your Honor, I think what's really, I've got to cite CCW. And CCW does state, which I think is really important, to emphasize that even when there is no evidence of violence towards children, it is appropriate to completely separate it is inappropriate to completely separate or compartmentalize a parent's history of domestic violence towards other adults from the best interest inquiry regarding the parent's child. Such compartmentalization conflicts with the statutory view that a history of violent behavior has relevance, especially when committed against the other parent of the child. Both common sense and expert opinion indicate that a parent's act of domestic violence can have adverse effects on a child, even if the child is not the direct object of such violence, and even if the child does not directly witness the violence. You've heard conflicting testimony. I know you have to make a call, Your Honor, in terms of credibility, but the one thing that's run throughout this entire case of all the evidence you've seen is we have multiple incidences of domestic violence being perpetrated by Ms. Paul against my client. We have only one incident that she's claiming of him injuring her, besides the one that both parties are, that the police are saying are incredible, where it's seen and it's seen on the video, it's defensive. And I think that lowers the credibility of it and makes it that we don't need it. We don't need her protective order. We don't want to put them on kind of the equal footing here. We need to call out who's the abuser and who's the one that's failing to protect from the abuser in the past and he's trying to protect today. I did want to mention, there's some text message I submitted, I think it's Exhibit 5 in my rebuttal, where she says he's a good man. And she apologizes for her behavior, but this is 2024 and it's still happening. Also, I know we have siblings in this case. There's two older siblings that Miss Paul has with Mr. Mr. Paul. And what I did want to let the court...
They entered into an agreement as well. And she was, I believe, going to undertake some was it alcohol counseling or
yeah, I'm not Mr. Paul's attorney, so I haven't really gotten into that, but I do believe you're
working
correct,
back towards 50-50.
The only point that I wanted to mention is that my client has already contacted Mr. Paul and they've worked it out so that they will be able to make sure that the siblings have contact, even if my client is the primary custodian, because he can take the kids over to Mr. Paul's.
Mr. Swinard, did she have equal custody of her other two kids? Okay.
Yes, it's 50-50. She and Mr. Paul were married for 7 years. They have a good working relationship, good co-parenting relationship.
Okay.
And then my final request, and I just wanted to say.
So what do you want me to do?
I want you to enter the protective order that we filed. I want you to deny her protective order. I want you to follow the guardian ad litem's recommendations in terms of parent time, set a review. We come back, we deal with it. We have the other case, which your honor holds.
Is part of this kind of a review right now? I mean, or maybe we're just waiting for more information from
DCFS.
the DCFS and the services.
But I think we should have that review to do it. I also think, Your Honor, I'll just put it out there. I'm happy to file the motion if you want to give me time, but there was a stipulation filed. There was a final order submitted that was declined to sign. She's now filed new financial.
Never reduced to a decree.
I just want to make sure that we don't have the immediate refiling of new documents. I would probably, if this court needs me to, file a motion to set aside the stipulation to readdress custody matters, as we have very many changes.
I'm not going to tell you how to strategize, but
I just want to give me leave to do so in the event that happens. So
I don't think that there's anything stopping you from filing a motion to set aside the stipulation that was reached.
Totally fine, Your Honor. I just want 2 weeks to do it so that I don't
anticipating
have to do it immediately. And that was all. So just 2 weeks leave in case they decide to file tomorrow, the final documents. But I think that's where it is. Does the court have any questions for me?
No, none further, except as far as reviews go, I think, Mr. McDonald, you were suggesting that we do that in this case. I don't have a guardian ad litem on board in the domestic matter.
My suggestion was to do it in this case, and just this might be helpful information related to that. My understanding is that the parents are supposed to be getting those assessments done. I think DCFS has given them a deadline of May 27th, but those assessments could get done sooner. But that gives you kind of an idea of where things are.
But there's no, you said you were reluctant to say on the record what the services plan was. I'd be interested in knowing what that was.
So what I'll tell you is
But
that
it is, yeah.
what DCFS is asking the parents to do is a DV assessment and mental health assessments, and then follow the recommendations. So that's sort of what the plan is going to be. We don't know what those recommendations are because the assessments haven't
We
been
know
done
how
yet.
far along they are in that process. So when we'll get those assessment reports back.
So again, the first step is having the assessments done, and DCFS has given them a deadline of May 27th.
May 27th. That's a while out. Okay.
They could get them sooner. That's sort of DCFS's, at least from my conversations with the caseworker.
All right.
That's what's supposed to happen. And if it doesn't happen, then I assume DCFS can't always file juvenile court petition.
Okay. All right. All right. Anything else before I go to Mr. Swinyer?
That's it, Your Honor. Thank you.
Okay. All right.
Only one point on the protective order, Your Honor, because it's been requested by counsel that a protective order is entered against Taylor, not Dakota, because Dakota doesn't need one against him. I do feel, again, setting aside all the domestic violence claims that my client has made against Mr. Mortensen and going to that question of need, does she really need a protective order from him? Does he need to have one entered against him? If we just look at this cycle and how long it's been followed by these parties over and over again, falling into old routines, bad patterns from both of them, frankly, there certainly is a risk that if he's not ordered to stay away from my client and not communicate with her, if there is not a protective order in place, there's certainly a risk that he's going to fall back to his old ways. So that is, among other reasons, why a protective order should enter.
All right.
On custody, I'm happy to address that now if you'd like, Your Honor. On custody, you asked, what's the vision for this case from here? Depending on how we handle it, we could either get some resolution, some movement, and a restoration of custody, or we could just go into an infinite review hearing death spiral, which I don't know if anyone's particularly interested in. It has been very difficult for my client to come up with words to describe how she's been affected by being cut off from ever over the last 6 weeks. And for the first 3 weeks, it was completely cut off. And then the court somewhat relaxed it beginning on April 7th. Again, that's at Dakota's request, the initial suspension. As the court already knows, this has been a huge break from the status quo that they've been following since Ever's birth. She shares custody of Ever's 2 other children, which the court has already...
Not Ever's, Mr. Paul.
Yeah, that's correct. She shares custody of Ever's 2 older siblings. Taylor and the 3 kids are accustomed to sharing a bunch of time together, and that's been taken away from them almost entirely. In our declaration that was submitted yesterday...
How far apart in age is Ever from the elder 2
They're
children?
close.
Yeah, 8, 5.
8 and 5.
Okay.
So they're pretty
All
close.
right.
They're bunched in together. They like to spend time together. Most of our declaration that we submitted yesterday was devoted to this normalization of custody of Ever. He is a happy and healthy kid. Hope he can stay that way. Obviously, there's some things we need to address here. My client pointed out in her declaration yesterday that she makes it a huge priority in her home to keep these kids off of screens, doing interesting things like art, playing outside, visiting fun places together as a family. It's been remarked by Tara Almond as well as Aspen May, the 2 supervisors in the case, that Taylor shows a lot of patience with the kids. Her harshest form of...
This is part of the reason why I was asking, why, maybe you should consider whether we should have had a paid supervision service observing so I could get a report from someone who's non-biased. In other words, not her sister or her friends or family members who were conducting the supervision, whose declarations, they're kind of inherently biased. They may be truthful, but they're inherently biased. as opposed to somebody from the outside. That might have been a little bit helpful for me as well, as in terms of how the kids were responding when mom showed up.
Sure.
Yeah.
I understand the concern, Your Honor, but bear in mind that multiple possible supervisors were suggested. 2 were vetted and selected.
Mhm.
And the part of the reason they were selected is because these supervisors, Ms. Almond and Ms. May, they have a great relationship with Dakota and Taylor. And I understand that on paper, they're more aligned with her, with Taylor, but you know, these are not
I think they
necessarily.
probably would have been more focused on their mom, but okay, the kids, yeah. All right, all right.
Understood.
It turned out the way it did, and I wasn't going to
Understood.
force it, so. All right.
Okay. So my client, she has the time, she has the network sufficient to continue caring forever. Her friends, her family members live here. Paid nannies live here. Dakota, we don't have a great sense of his availability to really be the full-time parent in this particular case, whether he's overly reliant on third parties. We know that he runs a small business. He rents a room in a home with a roommate named Crew, who apparently is here today.
Can I ask one more question too? We're going back to the parent time issue. This is what's more weighing on me right now. Is you had mentioned. I was really more concerned about what your client had gone through as part of her criminal probation in terms of classes, courses, etc. And whether or not some of that might be. You said she hasn't been drinking at all. I mean, has she been taking random UAs, that sort of thing?
Yes.
Okay. All right.
Yes.
All right.
So that's something that she did on the criminal side, and as Mr. McDonald has reported to the court, that's part of the services that DCFS is presiding over right now. Both parents have been asked and are willingly going to participate in a domestic violence assessment as well as a mental health evaluation. As far as the custody case, the court already understands and has pointed out the strangeness of the fact that Dakota agreed to give my client custody only in August of last year. And I do have to correct the record. It is not a 50-50 agreement. It is approximately 70-30 agreement.
Oh, that's right. That's right.
In my
Yeah,
client's favor.
Yeah.
So they followed this from the date it was signed. There were some exceptions for travel and work schedules. He never asked for supervision in the custody matter. By signing the agreement, it's obviously important for a variety of reasons. He gave custody of this child to Taylor only a few months ago. And I think that implies that he understands that she has skills, parental skills, parental fitness, and a very important bond with Ever. And he has an important bond. Ever has an important bond with Taylor. Sufficient to justify giving her custody of this young child. So at the time he signed this, at the time Dakota signed the stipulation, he had a laundry list of problems with my client. In fact, the vast majority of the baggage of their relationship had accrued up to August 22nd, 2025.
This is pertinent to parent time now?
I think so, because again, it does go to what's going on in his head. And so I'll get to my point right now, Your Honor. If he thought, this goes to the question of where is Taylor's anger directed? If Dakota thought that Taylor's anger could be directed at the children, if Dakota's not present, specifically Ever, if Dakota's not present, he would not have signed this agreement giving her custody of Ever.
Well, let me ask Mr. Hall just for 1 second here. You made reference to, I think, CCW
That's correct, Your Honor.
guidelines. That is.
That's
Can you elaborate on that a little
Court
bit?
of Appeals, State of Utah.
In Ray CCW.
In Ray CCW 2019, our Court of Appeals.
Okay, and that was in the context of compartmentalization when we're talking about violence towards
Anti-compartmentalization. We should not compartmentalize. That's the ruling from our Court of Appeals.
Do you have the side on that?
I do, Your Honor. It's 2019 Utah App 34. If you'd like the Pacific Reporter, I can give you that one as well.
Please.
440P,
okay.
3rd, 749.
All right.
And the specific spots that I quoted.
That's okay. If I read it, I'm reading the whole case.
Page 19.
Okay. All right. All right. You can keep going.
Thanks. And I only need another moment, Your Honor. Okay. This court observed I think correctly, that her anger, her outbursts are only directed at Mr. Mortensen. Mr. McDonald echoed this observation on April 7th. He noted that it's not directed at the kids. There has been speculation by our guardian ad litem that there's a lack of self-control, which could negatively impact the other children if there were outbursts at other people, including the kids. Now, I understand as the child's advocate here why he would make this comment, but there is no evidence to support this. The only evidence shows that it's a Taylor-Dakota problem, that her outbursts and anger are a Taylor-Dakota
I
problem.
still have to factor it in under the statute, right? Domestic violence is the #1 factor now when it comes to making custody and parent time determinations.
You factor it in, and it's also highly relevant that there are mutual allegations in this case.
That's right. There are mutual allegations.
Both parties have made multiple representations that we have a toxic cycle in this relationship, and it supports the argument that, again, it is a Taylor-Dakota problem. He admits our relationship was terrible over and over again, toxic over and over again. I think this next point is important, Your Honor. If there's a concern that unsupervised normal custody, so a 70-30 unsupervised arrangement, could subject the children to outbursts, that is hypothetical, and that has not been proven based on the evidence thus far. On the other hand, the harm being experienced by my client, by the 2 other children right now, is not hypothetical, it's real. It happens every time during these exchanges, and during every visit, every day that they're prevented from having a normal amount of time with each other. These visits are extremely disruptive to this child.
Well, are you saying I shouldn't be concerned by the behaviors towards Dakota in terms of, you're saying there's no way that would happen in another stressful situation that she might encounter?
Correct. She's uniquely patient with the children. And Dakota is uniquely...
Not entirely, because at least not when the 2 of them are together in the same
That's
place
what I
at
mean.
the same time.
So Taylor and Dakota, they're the common denominator here. That relationship, hallelujah, is dead and gone forever, and everybody will win as a result of that.
I don't know about that. I don't know if that relationship's dead and gone forever.
If the court enters...
That's part of what my thought process is.
Sure.
We're going on as I'm contemplating.
Well, we anticipate a protective order being entered today, which will be the final nail in the coffin. Obviously, we hope that there will be a co-parenting relationship that can form and
I agree with that.
Improve.
Yeah. I mean, that has to happen. I mean, I'll have some things to say about that too.
A couple of just updates from our perspective regarding DCFS, then I'm done, Your Honor. Both parties are engaged in voluntary services. The next meeting that my client has with the caseworker, Hiram, is tomorrow. The safety plan is being implemented. I don't know any details beyond what Mr. McDonald has already said. I expect those shortly. And so my office...
Sure. Didn't the parties receive copies of the safety plan?
I think that's forthcoming. And right now we just have the initial...
They usually sign off on it.
You signed a safety plan? No, my understanding from what Hiram has told me, the caseworker, is that will be entered into tomorrow. He's meeting with her tomorrow.
When was the case closure on this? When did the report
I
come
don't
out?
have the exact date, but CPS closed their case, I would say it was shortly after we were here last time, around.
And I never got the written report. All right.
I don't know if they would have, Your Honor, I think that they generally only submit written reports if there's physical abuse that's alleged.
I see. Okay. All right. Okay.
Couple more points, Your Honor. Both parties have been asked to do the assessments. Neither has started this. My client, we got from the caseworker today a referral, and so we're going to be reaching out and getting that underway.
Okay.
Also, she already has made, and they have already made some adjustments that are helping the situation. She's trying to take accountability and move on. She has been working.
In what way?
She's been working with a therapist. She'll continue to do so.
I don't have anything from the therapist yet. Right?
That's correct.
Okay. And is there a DV component to the therapeutic intervention here?
You can ask my client, Your Honor. It's a big theme in the therapy. They're going over it, talking about it.
Okay. All right.
We don't know if Mr. Mortensen is. From the tone of his filings, my guess is he is not undergoing therapy. Very importantly, Your Honor, party communications. So messages between Dakota and Taylor have stopped entirely. She stopped the communications long before he filed the protective order.
Well, there has to be some means of communication. They have a child.
Using a
in
third
common.
party right now.
Yeah. Okay, good.
Now, one thing you'll have to grapple with today is institution of our family wizard. My client thinks it'd be a good idea. If and when they resume those parenting communications, this might be a situation where we continue to use a third party for the time being, and then revert and then switch to our family wizard. I think continuation of using neutral location for exchanges would be helpful. Using third parties to facilitate exchanges will be helpful. This has been voluntary, Your Honor. I mean, her working with DCFS, her accepting feedback from law enforcement in terms of how to get some, make some adjustments to create some distance from Dakota. These have been voluntary adjustments that she's made. Some people completely disregard what DCFS requests, what input law enforcement might provide. But this is something that she's taking to heart.
Well, everyone says that they'll be in compliance. Time will tell, right?
Yeah, exactly. I understand. So at this point, again, we are asking for restoration of that custody arrangement that they agreed to in August. I'll just close with saying these visits, the back and forth, the abrupt end to these short exchanges with Ever and Taylor are excruciating for both Taylor, Ever, and these two other kiddos.
I just don't have an independent report. I think that's your client reporting to you, right?
As well as the supervisors, but also I think it's a pretty reasonable assumption to make that a 2-year-old child seeing his custodial parent after 3 weeks absence is going through a lot of confusion right now.
Different kids are different. Some are more resilient, some are more adaptive, but yeah, I understand what you're saying.
Yeah, understood. Thank you.
And I do have to address that speculation counsel made. My client is seeing a therapist.
He is?
He
Okay.
is.
All right. Well, let me go ahead and make some recommendations, but I may defer other portions of this. And I have to be honest, I've struggled far more with the parent time aspect of this than the protective order aspect of it. I think there's been, let me just address first this notion of passage of time and filing later on. The statute's pretty clear about that in the sense of passage of time alone not being a basis for denial of a request for a protective order. And I've seen this come up in multiple cases. And typically when I look at that language and I look at the cases where I've seen requests for entry of orders long after the incident occurred, it would be something in the nature perhaps of the context where there was an incident that led to criminal charges being filed. Somebody goes to prison. There's a protective order perhaps out of the criminal case that's in play. And then years later, they're being released. And now the request for the protective order comes in because of because now that level of fear comes back to the surface as the perpetrator is being released from prison. I do have some issues when we talk about lapse of time and whether or not it's okay just to say, okay, I'll just hold on to that and use it when I need it. When custody issues may arise, for example, years later, I'll go ahead and make my request for the protective order, knowing that there's this passage of time provision, and use that down the road. And I have a problem with that. But when I thought about it in this case, my part of what I thought was, well, if that was the case, there was a stipulation for equal parent, or excuse me, there was a stipulation for parent time, really, that effectively would have resulted in Taylor having the majority of the time. So if he was going to do that, there was certainly plenty there for him to do it before the stipulation was entered into, meaning that he knew about the incident in 2023, the incident in 2025 had occurred, and then the stipulation came after. And then after that, it's when the protective order was filed. So I don't necessarily think that was a primary motivating factor for him, at least to gain a leg up in a custody dispute, because I think he could have done that a long time before. That's not to say that I don't have some problems with the reasons why this was filed. or that I don't have some concerns about his conduct too. Both counsel referred to it. This has been a very toxic relationship. It's beyond the pale in a lot of ways, the toxicity here. And I've had some thoughts about this, about what's this dynamic that we're seeing here. I think that what I've seen from the evidence, even post last hearing, some of it was before the last hearing, some of it was after, was in some there seems to be a continuing attraction that they have for each other, whether it's physical, whether it's the thrill of the two of them, being a part of making themselves celebrities. There seems to be this attraction that they continue to have for each other. Each of them have been texting each other, wanting to get together for physical relationship, to continue on to the physical relationship. In some cases, she's invited him over. He said okay. In other cases, he wants to come over, and she lets him in. And the problem is that the two of them can't be together in the same place at the same time for very long before it starts to turn violent. And that's part of the problem. That I am very concerned. And I think I just have to say it. This is not anything that I don't say in a lot of other cases, which is that you guys have to figure out a lot here. You have to figure out how to function as co-parents. This has been dysfunctional. This is a lifelong proposition between the two of you. You're going to be, you're linked together for the remainder of your lives. You're going to be the grandparents of the same grandkids someday. You'll be their same graduations, their same weddings. You're modeling right now how you deal with conflict to a 2-year-old. This can affect this child when the child grows up and becomes an adult and is in his own personal relationships as well. When we talk about cycles, this is part of your legacy. This is the legacy of violence being passed on from perhaps generation to generation. I don't know. I'm not familiar with your childhoods, but it's certainly concerning all the way around. Meanwhile, I have to make some decisions about, because you couldn't come to agreement as between yourselves, I have to make some decisions about not only entry of orders, but then on top of that, if not here, then in the domestic case as well, about what your parent time arrangement is going to look like, at least for the short term at this moment. I think there's some merit to both of their arguments about their bases for protective orders. I certainly think it's an easier call with respect to Dakota's request for a protective order. The video evidence is really overwhelming, and in terms of the elements that go into that give rise to the basis for the entry of a protective order. At the same time, I think there's also evidence, and I'm finding, at least with respect to the May of 2025 incident, that while the bruising, the injuries that Taylor suffered, it's certainly possible that some of these injuries could have been the product of self-defense, but I'm not finding that it's probable. I'm finding that there's been violence that's occurred both ways between these parties. Now, the difference, I think, is that with Taylor, is that her conduct is more reactive. That Dakota knows, and I think that she had indicated this in her paperwork as well, is that he knows how to, and I alluded to it at the first hearing a little bit as well. Knows what to do to get under her skin, so to speak, and she reacts. She gives him the reaction that I don't know if he's necessarily looking for it, but she certainly gives the reaction. I'm certainly a little bit. I take some issue with his representations, with Dakota's representations, that his entire motive behind all this was simply to break the violence, the cycle of violence. I think first of all, there's a little bit of conflation between when the parties refer to the cycle, certainly there's been a recurrence of incidences between this party, but it's not necessarily, and maybe in some respects it is, when we're talking about the cycle of domestic violence. All right, an incident occurs, then there's sorrow, apologetic, promises to make changes. Then there's this honeymoon period, where they're trying to work things out. Then the tension builds again. There's another incident, and then it's all happens again. I'm just not necessarily persuaded that all of this had to do with child protection. I think some of it was, but I'm not sure that all of it was, because when I reviewed some of these videos that were taken by him, and quite frankly, this is I haven't really seen a case where the video evidence was of such a degree that I'm seeing in this case, where there's this where it's handheld type video that during the incident, as opposed to it being, say, a Ring camera that might have been in the room that's recording everything that's going on at all times, where we could maybe go back and look at the whole thing. This is handheld stuff. So he's got this child, for example, in the May 2025, the earlier part of that, I believe it was May of 2025, where he's holding the child in his arms, she's attacking him. I didn't view the video as him trying to leave and get the child out of there. I viewed him as him standing there being more interested in whether this video recording, he's looking into the camera in some instances, I think in a couple of these videos. One where I think somebody else was filming him while he's sitting in a truck and he's on the phone with Taylor. And so I think part of that is, a greater concern about preservation of evidence than it was about removing the child from the situation, which I think is borne out by the fact that he was supported as well by the DCFS for failure to protect. So that's so as far as Taylor goes, I mean, I think the nature of her conduct is really reactive and the kind of this inability to control emotions. I think his conduct really is more, well, how shall we say, give me 1 second here. I think it's more deliberative. I think in the sense of subtle, maybe is one way to put it. I think that there is some manipulation. I do think that there is some obsession. I think there may be obsession that they may have with each other as well. But certainly I have some issues when I see the photographs of the evidence that he asserts it's more probable occurred through was the result of self-defense. I don't feel that's necessarily the case. I think it's more probable that he caused these injuries to Taylor, and I do think she's met her burden as well. And I do think it's important that there be mutual orders as well. They need to stay away from each other. Part of my concerns and my thought process as I go through this is I'm wary when it comes to the supervision aspect of it, although I'm not going to make a decision on that right now, that if I'm continuing to supervise Taylor's parent time, I'm wary that Dakota may actually try to use that as a way to manipulate and control her. I think I'm just not persuaded either that with Taylor's filing that it was solely due to breaking the cycle of ending the relationship. I mean, I think there's some merit that I'm giving to the declaration of Jesse Draper as well. At the same time, I don't think there's an extreme power imbalance between the two of them. I don't think necessarily that Dakota was exercising some kind of necessarily like blackmail, because there's several references where she was inviting him over to her home as well. She shouldn't have been inviting him over. He shouldn't have been going over. And I am just concerned that if I don't order both of them to stay away from each other, that there's going to be some additional problems that aren't contemplated at this, that may not be contemplated. I don't know what to say in terms of what happens when there's mutual protective orders and they find themselves at the same restaurant or at the same bar or whatever the case may be, hopefully not bars at this point. And you're both potentially being subjected to criminal charges if there's a violation of these protective orders. I'm hoping that you're not people who just thrive on the drama and the conflict. You've got to put your child first and shield the child from this conflict. All right, so my recommendation is going to be mutual protective orders. I want there to be 100-foot stay away for each of their orders. I'm going to leave the current order in place. I need to think a little bit more about this lifting of supervision. I have mixed feelings about it. On the one hand, I do have some concerns that if Taylor is in a stressful situation, she has not demonstrated an ability to control her emotions. But as I also said, that seems to have only happened when she's been in the same vicinity with Dakota. And like I said, I'm wary about the supervision aspect. The court, I guess I should say this, the court would have the regardless of what either party may want, the court would have the ability to lift the supervision at any time. I do think there may be some benefit in waiting to see what's coming out of the assessments that have been ordered from the safety plan. I think there's some benefit there, but I'm also contemplating additional time as well. What I meant to say earlier, the word I was looking for is I felt that Dakota's behavior was a little bit more calculating rather than reactive. All right, so I'm going to take under advisement the issue of parent time. Interestingly, over the next week, I'll be in DC at a domestic violence training while I'll be processing all this. So I'll have a written recommendation for you by no later, I'm hoping, than the 11th of May at the latest. Any questions about the PO? In terms of the PO?
You want to modify it in any way with parent time?
No, same parent time.
And parent time means what order listed.
Same parent time as we have up to today, but I'm going to make a recommendation about that parent time on or before May 11th. So I may make changes at that time. And then if that happens, we'll issue a modified protective order that reflects the new parent time order. All right. That's a good idea.
I didn't hear that.
Review hearing.
Oh, yeah.
No, I want to put it on a special setting. I'm just wondering how much time do we think we need?
In my opinion,
You asked for it.
I know. I frankly don't think we're going to need a ton of time. I mean, what I want to do is get those.
I don't want to put it on my regular protective order calendar where I have 15 other matters.
I think that's a good idea, Your Honor, not to put it on that calendar.
I mean, depending on how much time you have, I think if we set it for an hour, I think we would be done in an hour. and might be done in less time than that, frankly.
30 days? I mean, are we, yeah. Or do we need more time than that?
I mean, do we want to have the assessments back?
I don't know.
I would like to have the assessments back, but I'm good coming back in 30 days and seeing where we're
When are
at.
you going in to take your assessment?
I mean, we're going to do it ASAP. I mean, we have the referral for it.
Let me ask the counsel for the parties.
DCFS hasn't given my client a referral for the assessment yet, but he's been in contact with them and they've been chatting. He's done everything they've asked. So I can make sure we push it up and make sure they get that referral. I would estimate, just based on my knowledge of DCFS cases, Your Honor, and how they go, I think 5 weeks would be the minimum for a review.
Okay.
And I agree with that. And that pushes us out beyond the team meeting that's scheduled for May 27th.
Early June? And I do want to work with both of you to try to restore this to some sense of normalcy. I really do. I just think right now you two need to stay away from each other, and there needs to be orders that will, result in consequences if you attempt to try to engage each other. Because I still think you have this attraction to each other, physical or otherwise. June 1 at 2 o'clock.
I am available, Your Honor.
That'd work for me.
Okay, Mr. Swinyard.
Would we perhaps be able to do it via WebEx? I expect to be out of town that week.
If you want to make a request for WebEx, I think you have that right. The way I read the rule is that we're supposed to grant those requests unless there's a real compelling reason, like you're going to take somebody into custody.
Sure. No, then we can make the first work. And obviously the court is evaluating different scenarios for the next 5 weeks.
And I want to read the case too that Mr. Hall had alluded to, because I think the suggestion there was it's oversimplification to, if I'm making a ruling, I don't want to run afoul of the statute, or excuse me, of the case law. If I'm unduly compartmentalizing, saying everything will be fine as long as she's not around him, right?
That's what the case says. You can have my copy if you'd like.
Okay. All right.
What time on the 1st?
I had
2 o'clock.
2 o'clock.
2 o'clock.
WebEx is permitted.
Mm-hmm. Do you want to do it by WebEx, everybody?
I think it's been a
Make it a
long
remote
day,
meeting.
and I'd probably want to talk to my client about it, but I love the option.
Okay. All right. So next 10 days or so, I should have the recommendation on parent time. At the very least, I'm inclined to expand parent time. The bigger question for me is, should I be lifting parent time? I think you want to go all the way back to the terms of the agreement. I think I'm kind of more inclined to take baby steps towards getting there. But that's, I think, in a lot, but I don't have really a petition to set aside the stipulation. You were talking about that too. So I don't know really what the objective is otherwise, other than what they had stipulated to before. If that motion's filed, that might change. There may be differing objectives there, but where they've already reached an agreement, typically when I'm restricting parent time, I'm trying to work back to where they were before, unless there's ordinarily a petition to modify. Yeah.
That was why I mentioned it, Your Honor, is that I'm more than happy to mediate and work through something and not just file a motion to set aside.
Please do.
What I don't want to have happen is within the next, few days, and I'll happy to discuss it with Mr. Swinney, have just final documents filed and I have to rush one in. That's all.
Okay. All right. All right. Well, I certainly encourage the parties, to the extent that they can, let's check the box for mediation for sure.
Yeah.
Because I do want them to keep working on trying to resolve these disputes. Ultimately, it's the hope of the court is that's the place where you get. So you're not dealing with judicial intervention. You're not coming here, giving up all your power and having the court force orders on the two of you that with the assistance of counsel, you're working out these disputes between yourselves. That's my hope. I mean, unfortunately, you've been unable to do that thus far.
If we can find a mediator between now and June 1st, will the court order us into mediation? We can give it a shot there.
Do I need to order it if you're?
You don't need to order it on our part. And I believe our protective orders will have an out for mediation, if I'm not mistaken.
It'll have a
Protective order
box
should-
checked for mediation.
Yeah,
They'll
We're
allow
so
it
just
for
asking
mediation.
if council would stipulate to an early mediation.
Yes.
Okay, all right. If you're both okay with mediating and working on it outside of court, that's something I'm typically always encouraging. I know there's some DV aspects in terms of, I'm not going to force mediation in a protective order case. Let's put
Most
it that way.
mediations now are online in separate rooms, and we never see each other anyway.
Right,
So
right.
yeah.
I mean, if we didn't have Mr. McDonald on the case, this might have been a good one for referral into the new pilot program. But that's presently, that's going to screen it out presently. Okay. All right, we'll come back and have a review hearing then on June 1st at 2 o'clock. But before then, you'll get a recommendation from me in writing about parent time. All right?
Communicate with the petitioner and third party. Speak contract says legal representative. You still want that?
Let me look at it.
And those are right here.
It does create, don't want to speak for Mr. Swinyard, but it does create a little bit of a, I guess, chore for attorneys to figure out the parent time schedule week to week.
Indeed, yep.
Week to week?
We've been doing it week to week.
Let me take a look here.
And adding to the difficulty is having to coordinate with supervisors. So hopefully, if and when that's lifted,
Well,
it
the
will simplify.
supervisors are kind of aligned with her, aren't they? Are they making themselves available at?
Yes.
Or they have their own lives
It's-
too.
You know, it's still a challenge though.
How many do we have?
2 currently.
2. Did you want to expand that? Is that what we were talking about?
We can attempt to. I mean, we would need to speak with our client and go through the previous system of sending them through Mr. McDonald. We're happy to do that.
I mean, I hate mentioning professional agency, but I believe there's some professional agencies that can at least coordinate. Or we could use, well, I don't know if our family wizards just yet.
Right.
I agree.
That we don't have a third-party intermediary for communicating, or they just did that on their own?
No, we've been doing it through council, which is
Through
not
council.
sustainable.
I don't think that's a role you want to play necessarily, is it?
Wasn't going to say it, but yes.
Well, I'm okay if the supervisors want, I mean, if you're arranging through parent time, arranging supervised parent time at least, that's going to have to be at a time that's where the supervisor's available. Can the supervisor act as the third party intermediator for making parent time arrangements?
We could, but when we have affidavits filed in cases against my client, it adds to that bias.
It
concern.
does,
If
doesn't
we could
it?
have someone that's neutral, it'd be excellent.
Parents of each of them? Are they hostile towards each other as well? The two sets of grandparents?
I don't believe so.
What I can do is I can submit names no later than tomorrow, and maybe council could do the same, submit 2 or 3 names. And I think this is something we'd be able to sort out because you're asking not for a supervisor, but someone to coordinate parent time.
Well, as opposed to the 2 attorneys, as
Right.
opposed to the council.
Right. Just understand, just make sure I understand the role.
Yeah.
We could submit names as well. We might need until Monday, but
All right.
You going to be able to work that out without me having to make
I think so.
that decision as well? Okay.
Well, one easy way, Your Honor, is to give Mr. McDonald the final call if we have a disagreement of who could do it well.
I would be happy to do that.
Okay. All
All right.
right. As long as you're willing. All right. So I'm sorry, back to your question.
I just wanted to know if you wanted me to list somebody's name in there specifically, or if you wanted me to.
Let's just say is mutually agreed, and if there's no agreement, then to be determined by the guardian ad litem. But again, this could all change in the next couple of weeks. I am contemplating lifting supervision. I just want you to know. Okay. Okay, anything else from council?
Nothing from us, Your Honor.
Okay, wait right here. We'll get the protective orders issued. These are now 3-year orders, just so you're clear. These orders that I'm issuing now are 3-year orders. They're designed to expire on their own after 3 years. They're not criminal orders. That doesn't result in a criminal record. It does go out on a database though. So if there's an incident that occurs, the police show up, they can run and see that there's a protective order in place, arrest can be made, charges can be filed. First time around, it's a Class A misdemeanor. Subsequent times for violations, 3rd-degree felonies. I'm really intent on trying to keep the two of you away from each other for now. All right? And then later on, as hopefully the dust settles, we can perhaps scale some of that back a bit. All right? I just think that's what's best for your child as well, that the two of you not be in the same place at the same time with each other. I mean, all of the evidence seems to suggest that's a bad idea. Mr. Swinyard?
I mean, Mr. Mortensen's other?
With
Diaz.
Oh, yeah.
Joel Kittrell, Kittrell.
So we're going to issue the orders. I want, you can flip a coin if you want. One of you leave first, the other remain behind in the courtroom and until one is able to leave the premises and then the other can
My
go.
client volunteers to go second.
All right. Okay. You do? Okay. Okay. Bailiffs have that worked out. All right. Don't leave yet. Don't leave yet. We've got to get you the order.
And then we'll escort both of you out. Is it okay if I speak right now, Commissioner?
Yes.
So for everybody that's here in the media, I've been advised, courtroom is closed. If there's any interviews that want to be engaged in, we are requiring that you step outside the property and then you can engage in any interview process. But nothing will occur inside the property. Does anybody have questions on that?
Meaning the broader courthouse.
The courthouse itself inside. Once you exit the doors, have any interviews that you'd like to.
Understood.
And we'll escort you out.
Appreciate that.
Nine 9071.
Hmm?